If you're accused of a serious crime, perhaps a murder, perhaps the police case is circumstantial, there's doubt about whether you did it or not, in whose hands would you want your fate? A jury of your peers or a judge? 922 11882. My next guest on the program thinks that it needs to be looked at again, this whole question of judge versus jury. He's Aaron Stonehouse. He is the Liberal Democrats MLC. Aaron, good morning.
Hi, Gareth. How you going?
Yeah, I'm really well. Just explain why it is that you want to have another look at this issue.
Right. Well, I mean, essentially what I'm trying to do is just give people the choice to begin with. A trial by jury is important. I think it should be a right, but it shouldn't be forced upon you. You shouldn't have an obligation to a trial by jury. You should be able to choose between a jury or a judge. The main reason why, I believe, is because when you get a trial by jury and a jury gives you a verdict, they don't have to give a reason. They just tell you guilty or not guilty. So if you want to appeal a bad decision by a jury, it's very, very difficult to make an appeal against a simple verdict of guilty or not guilty. There's no reasoning. They don't have to lay out how they arrived at that decision. It makes it for a very difficult time in appealing. So if you happen to be innocent and you're convicted of a crime, trying to go through the appeal process is very, very difficult when you're trialed by a jury alone.
Okay, 922 11882. I wonder where you stand on this. Do you prefer... would you prefer your case to be heard by a judge or by a jury? Aaron, the situation at the moment is that the presumption for certain offences, once they go beyond a level of seriousness, is that cases are heard before a jury, but a defence team can elect to make a submission to have it heard before a judge, and then the court will decide whether or not that's accepted or not. That's basically the situation at the moment.
That is correct, but the burden is then on the accused to convince the court that it's really in the interest of justice to have a trial by a judge alone. And that could be quite difficult. What my private member's bill would do is basically reverse that burden. Give the presumption that the court will issue a trial by judge alone if you ask for it, and if it's not in the interest of justice, then the prosecution and the court can basically prove that point and decline that request. So it just makes it a little bit easier for people who are concerned about a trial by jury, giving them that choice there to ask the court to get the trial by judge alone. And there are a lot of reasons to be concerned about a trial by jury. I mean, if you're arrested and it's quite public, how can you be certain that the jury is going to be indifferent about your case? How do you know that they haven't gone on Facebook or Google and already researched your case and already made up their minds before the trial even begins? In today's age, everyone's connected. You get your information straight away. A lot of people make up their opinions, based on a headline without even reading an article. So I think, as technology changes, we should make, our trial by jury, an option rather than an obligation.
The legal system has always dealt with this by having judges deliver specific instructions to juries that they only regard what's heard in the courtroom when they do their deliberating. Yeah. I mean, do you think that system is failing?
Well, look, I think that's fine, but it takes a lot of time and at the same time a lot of resources too. A trial by judge alone can be a lot quicker, saving the state a lot of money. But again, it's not about forcing one way or the other. It's really about just allowing that choice. So, if you think you're in safe hands with a jury, by all means continue with a trial by jury. But if you have reason to be concerned that the jury may be influenced by something they've already seen, or if you think, you'd rather get this over and done with quicker, then just giving people that choice there to ask the court to issue an order for a trial by judge alone. That's really all my bill does.
There's a range of rationales for having a jury involved in a judicial process and making a deliberative decision after hearing the evidence. And the historic precedents for that go back centuries. But one of them, I think, one of the key issues for mine is that it gives the community a stake in the justice system. It gives confidence that the ordinary man in the street or woman in the street hears evidence and makes an assessment, and that a group of those people are able to formulate an opinion based on the evidence presented to them, and that actually gives us all a stake in the justice system. I would argue it gives us confidence in the justice system. Do you worry if your bill passes that the community stake in the justice system in any way would erode because that connection is lost?
Look, that's a good point. what I'm looking at is something that advances the interests of justice.
Yep.
And I mean, having a trial by jury where people are involved in the process may be good for instilling public confidence, but does it advance justice? You know, if people can bring their own prejudice, if they can make up their mind based on a Facebook post, is that in the service of justice? I think in some cases it may not be, and that's why I think having that option there is important. You know, further, when it comes to engaging with the public and letting them see what's going on behind the scenes in the judicial system, I think a judge trial is better because you get that reason. You can see the reason. The judge has to lay out in plain terms exactly how they arrived at their decision, whereas a jury does not. So while those involved in a jury case may be confident in the ruling, those who aren't have absolutely no insight into how the jury arrived at that decision. So I think, you know, giving that option there is better in service of justice, but also adds to transparency because you get a reason with every judge-alone verdict.
It's an interesting discussion. Love you to be part of it. 92211882 if you've got a view on this debate about whether you would prefer to be able to have your case heard in front of a judge or a jury. Obviously, defendants can apply to have cases heard in front of a judge alone. But as you're hearing Aaron Stonehouse from the Liberal Democrats explain, he would like to see that made easier so that defendants do have the choice. Aaron, do you believe that judges make better quality decisions than juries?
Look, it's hard to say. The judge, I've spoken to a few retired judges. I've spoken to a lot of lawyers, and the general impression I'm getting is that they want this. They want to have that choice. A lot of judges, actually, retired judges that I've spoken to, are happy with this idea because they think that they can get those trials over and done with a lot quicker than a jury can. A jury has to be impaneled. They have to find people. They have to pay them. They have to give them very specific instructions, which takes a lot of time too. And a lot of submissions can't be done written. They have to be done orally. So that, again, takes up a lot of the jury and the court's time. I mean, do I think that a judge or a jury is better at issuing out justice? It's hard to say. I mean, a judge is, you know, this is their profession. They have to weigh all the facts, all the evidence. They have to give those reasons. So I think a lot of the time their reasoning is going to be a little more solid. But, you know, at the end of the day, I don't think a lot of people, based on the retired judges and lawyers I've spoken to, I don't think a lot of people actually take up judge-alone trials. There may only be a few people using them. You know, generally people actually like their chances better with a jury. They can, you know, normally get a not guilty verdict out of a jury a little bit easier than anything. So, you know, I don't know if it's that one is better than the other, but in the interest of justice, I think having those reasons very important. And I'm not the only one saying this. You know, Malcolm McCusker has said the same thing. You know, you'll probably find a few prominent lawyers in Perth as well have spoken out publicly about this. A lot of people want this. I think the Attorney General himself in the past has pushed the same idea, has been warm towards the same idea.
Aaron, you're saying you're formulating a private members bill that you'll introduce within a few weeks when Parliament resumes. Have you had any discussions with your parliamentary colleagues? Obviously, as a private members bill, you've only got limited time to debate the various bills. Any chance that this will actually get to a vote? Have you had any discussions about that with anyone?
Look, there's a pretty good chance. What it will really come down to is the Labor government, and if the Attorney General is willing to back it. You know, I'm sure that myself, perhaps the crossbench, perhaps the Greens will be keen on this idea, but really the ball is in the Labor Party's court now. If the Attorney General can back this idea, we'll get it through. You know, the Attorney General has a lot of great ideas about how to reform the justice system. And I'm on board with that. I'm willing to help him do it. I think the Greens Party probably have a few views along the same line. It's just up to them to have the political courage to actually make those changes. You know, if we want to put through reforms like this, like judge-alone trials, we need the Labor Party to come to the table and be prepared to put their money where their mouth is and actually vote for this stuff. I've spoken to the Attorney General. He hasn't given me a firm position yet. He's warm on it, but you know, he still has to take it to Cabinet, I suppose, and we'll see where they land on it.
All right. It's a really interesting discussion, Aaron. Appreciate your time on the program today.
Yeah, thanks, Gareth.
Aaron Stonehouse, Liberal Democrats, MLC.